Hello, good evening and welcome to this week's BizSmart Webinar. Our weekly webinars are aimed to provide advice and share knowledge on key business topics and specialist areas. Our host today is BizSmart Select member Mathew from Advantage Management Consultants, here to talk about intellectual property protection. Before we start our webinar, can I ask you to use the question mark function on your screen to post any questions that you may have for Hugh, and he will answer them all at the end of our session. Okay, thank you very much. Over to you.
Hello everyone, it's Mathew here from Advantage Management Consultants, and this is about intellectual property, as Caroline said. Okay, so intellectual property protection. Some types of intellectual property protection are automatic and others you have to pay for. So let's give you an example. If you sketch a picture of your house, you will have some intellectual property on it. If you design a football in the shape of a banana, you could have some intellectual property there. Those are going to be automatic intellectual property protection. You haven't applied for anything. It's not very good protection, but at least you have some protection because you have done those particular things. Let's take another example. So you have to apply for some of the protection, and these may be refused, and they may cost you money as well. You can only obtain intellectual property protection on things that you create, not something which is merely an idea. I'll just illustrate that in a couple of ways. So if you say to yourself, wouldn't it be nice to keep dry in the rain? You don't get intellectual property protection on that. It's just an idea. If, on the other hand, you design an umbrella, you may be able to get some protection on that because it may be novel. You might say, if I clap my hands, it will open. That might be novel. It might be something no one else has done before, and you may be able to get some protection on that, except, of course, the fact that I've just suggested that to you, so it's in the public domain, and it was my idea in the first place. So here's an example. You're with a group of friends and you say, let's make a film about rabbits. That's no intellectual property protection derives from that, but of course the people who wrote the script for Watership Down had some protection in terms of copyright. So the sort of questions that people ask themselves, and I get involved in this not as a patent attorney, because I'm not a patent attorney. I get involved in this with companies who discuss with me what sort of protection they may need, if any at all. And these sorts of questions are very important to ask at the outset before you go rushing into these sorts of this sort of field. Do I need or do I want it? What have you created? What will you use it for? What is exactly that you think is so good about what you've just come up with? And will everybody else think the same? Or is it just something which you should think, well, aren't I clever, so-and-so, and I'll go on to something else? One of the things you might like to ask yourself is, who do you think might copy this idea of yours or the thing that you created? And do you really care about it? I mean, if you've got something which is really good, maybe you want everyone to copy it because it's a jolly good idea and you think it's going to be useful for the world and his wife. What's it worth? What is the idea worth? How do you define what it's worth? And how much will it cost to protect it? Because the first thing that you need to realize is intellectual property protection can be very, very expensive. Most people, when they think of intellectual property protection, think of patents. Don't know why, but they just seem to think that patents are intellectual property and intellectual property is about patents. But there are three other main areas that you should be aware of. Design, copyright, and trademarks are the three main areas, as well as patents, which should be thought of in terms of intellectual property protection. And there are other ways that you can protect your intellectual property or your products as well. Non-disclosure agreements are important. If you're talking to people outside of your own company, then if you're talking about something which you want to keep under your hat or you want to protect in the future, non-disclosure agreements are absolutely vital. If you're talking within your own organization, confidentiality agreements with your employees are also extremely important. Trade secrets is something that was around before we came across patents, designs, copyright and trademarks. They've been around for years, and they're still in force in some cases. We'll come on to those as well as a special case later. So patents. Patents is the first thing I'm going to discuss very quickly. Patents protect the way things work. It's very important to understand that distinction. It is how they work and how they're made. So something like the bagless vacuum cleaner. Mr. Dyson and all his engineers coming out with very clever ideas, patented all sorts of things to do with the way that the vacuum cleaner worked. Sadly, a lot of people copied it. They got round the patent. They did something slightly differently. And sometimes Mr. Dyson took him to task and sometimes he didn't, depending on whether or not, frankly, because he's a good businessman, whether it was worthwhile or not. And sometimes coming to agreements with people saying, well, you can use my technology, you just have to pay me a little bit for it. As before, a new design of an umbrella we talked about. Umbrellas have been around a long time, but a new one, something that works in a different way, like clapping your hands and letting it, I suppose that's probably been, there's a patent on that probably somewhere, but something really novel that could also be protected by a patent. You're protecting the way it works, not the fact that it might be triangular in shape. One of the things I'm working on at the moment, interestingly enough, in the flood business, a device to prevent water from coming up through the sewer through a downstairs toilet. You'd think that actually there might only be one way of doing it, but there's lots of different ways of doing it, some of which are successful and some of which aren't. And that's another lesson to be learned in this. You can get a patent on something, doesn't mean to say it's going to work properly, or indeed if anybody's going to buy it. In order for a patent to be granted, the product must be new, not disclosed previously by you or anyone else involved, unless it's through a non-disclosure agreement. Inventive, a novel idea that no one else has thought of, and the patent office will point out whether they think someone else has thought of the same idea. And it needs to be able to be made or used. Your patent application, made up of 4 parts, will involve description of your invention that allows others to see how it works and how it's made, the claims, the legal statements that set out the technical features, a summary of all the important technical aspects known as the abstract, and a diagram as well. All those things are needed for the application. Patents last for 20 years with renewable fees every year. Those are expensive. They're particular to individual countries. A patent in the UK is not a patent in France or Germany. You have to have a patent in those countries as well, and that will cost you extra. There's no such thing as an international patent. You have international applications and European applications, which I'll come on to, but you cannot get an international patent. You can just have the application process, which is either UK-wide or country-wide, EU-wide or worldwide. The powers that be are working on a European patent. 2020 is the date, I think, at the moment. Whether that happens, we wait to see, but I suspect it'll be a little bit longer than that. The application process, as I said, will be either through the UK Patent Office, European or worldwide, depending on your ultimate marketplaces, whether you want to take it to France and Spain and that's about it, or whether you want to take it further afield to Australia, New Zealand, America and places like that. So you apply through the UK Patent Office, you apply through the EPO for Europe under the European Patent Convention, and there's a Patent Cooperation Treaty, a PCT application, covers 145 countries at the moment, which is for the worldwide application. So that's where the application goes, and then you draw that down into individual countries at a later stage. In the UK, a patent application costs you a few £100, plus the fees for the patent attorney, the fees will be £20 for an application, £130 for a search, £80 for a substantive examination, things like that. When you get to year 5, the annual renewal fees start at £70 and they go up to about £600 a year for year 20. In the EU, it gets more expensive, a filing fee of €120 or 210 if you don't do it online. Searching fees of those, they really clobber you on claim fees. Depending on how many claims you have, and one of the flood claims that I was talking about earlier had 53 claims, then if you want to do that in the UK, it would cost you an awful lot of money, because they charge you nearly €600 for every claim over 15. And also, if they have to put them on extra pages, it's such a tiresome thing for them. They charge you €15 just for putting an extra page on. And the examination fees are horrendous. So your patents, each country in the EU or anywhere else, you'll have to pay extra fees. In the EU, the fees are similar to the UK, just to give you an idea. And it's an expensive process. So it's not something to be taken lightly. But applications in patents can be very useful, because you can scare off the opposition for a while and then not continue with your patent application once it's reached a certain stage. So before it gets to the very, very expensive stage, you can just jack it in. And maybe you will have obtained a commercial advantage by having a patent application which has scared people off and put them 3 years behind the pace. So design is the next. Design right and registered design are different. Design right is something you get automatically on something which you make. If you sculpt something, for instance, a 3D object, design right would be appropriate there. A registered design is something you apply for and you have to pay money for. These rights protect the way things look, just their appearance, not the way they work. That's a patent. It's the way they look. So, for instance, a smart car or Doc Martens boots are quite good examples, I think, of the way those things look. They are particular shapes, and it is the shape. They have trademark implications, those two as well, but we're talking really about the shape of the smart car or the shape of that particular boot. It's very distinctive, and it hasn't been used before. Design right is the one you get automatically. It's automatic, but it's also unregistered. It's free, and it lasts in the UK for 15 years or 10 years after you first sell something, whichever is the earliest. And that design right pertains, but in the last 5 years of a design right, you must grant a license of right to somebody who wants to use the same design. You can argue about the cost of that, or how much you're going to charge them, and that might have to be arbitrated by the Patent Office. But you must grant them a license of right if an amount of money can be agreed upon. In the EU, that unregistered community design, it's called, lasts only 3 years, but it does cover all the EU countries. In order to prove that you have some rights in that design, it's advisable to send yourself a copy of the design by dated registered post. Keep that thing unopened, of course, in case it needs to be brought out in court. And probably lodge another one with your solicitor, where you can bring that out during the process of claiming your right, if of course you want to claim it because someone's infringing it. Keeping copies of drafts of history of development, I always like to advise people to do that. It shows along the way how you developed that design, and it's further proof that it's yours and nobody else's. And of course add your name and date to all the documents. Registered design gives more protection than design right. It's quite a good protection, registered design, and you have to apply for it. You have to show the office that it must be new, it must be not published or disclosed beforehand. There are certain exceptions on that. If you put it out there at an exhibition, you get an extra 6 months, things like that. It's complex. It's far more complex than I can cover here. Main thing is that it must be different in appearance from other designs. It must be very distinct. Low cost, it's pretty cost effective. It's £60 a design, but you have to renew that every 5 years. In the last 5 years of the 25 years it lasts for, it costs 450 quid. Outside the UK, you need to apply there again, because it only applies in the UK, that registered design. But the good news here is that there are countries that work together. So in the EU, you can apply for a registered community design for all countries in the UK, in the EU rather, including the UK, through the Office for Harmonisation in the Internal Market. And for worldwide, you go through the Hague system for international registration of industrial designs, and that covers 64 territories. So it can, although those are expensive, they are cheaper than actually going to individual countries. So registered design has a good deterrent effect. It's easier to enforce than design right and copyright, because the other two, although free and automatic, they are unregistered, and therefore it is much more difficult to prove that you have rights in those particular ways. So design right applies to three-dimensional things. So if you, as I said before, if you sculpt something and you make something, the design right is yours because no one else will have made it in that particular way. Copyright, which I'll come on to in a minute, applies only to two-dimensional things. So it's works of art, it's works of music, it's things like that, scripts, that sort of thing. Registered design applies to both. So the smart car drawings and the smart car itself would be the subject of a registered design, and they would, and the registered design would apply to both of those. So copyright, it exists as soon as you fix the work, so as soon as you write it down. So if you're writing down a business plan, for instance, you'd have copyright in that. Software is it's a minefield really, but when you actually write that down in a two-dimensional way, that's copyright does exist in it, but it is much better to get further protection. It lasts 25 years, longer for music. It's free, no registration needed, but you again need to do the same things as you do for design right. But there is an international convention which applies to 168 states called the Berne Convention 1886. It was started, and the UK, although they joined in 1886, only started applying the Berne Convention in, I think it was 1986. It took us a bit of time to get things legal, and the US is pretty similar. But they are now covered in the 168 states. Send a copy to yourself by registered post. Mark it with a C in a circle and include the year. Add your name. Lodge a copy with your solicitor. All the usual stuff. Trademarks. Trademarks protect a brand. They differentiate you from your competition, and you are trying to make a name for yourself in a particular area of the market. With a particular name of the product or service that you're providing. There are a combination of words, or the best ones are the combination of words, logos, colors, and etc., rather than just a word. And they distinguish goods or services from similar offerings from competitors, and they must not be descriptive of the goods or services themselves, or indeed offensive. UK registration. It's £170 plus £50 for each extra class, and it lasts for 10 years, and it goes on and on and on, and every 10 years you have to renew it at £200 plus £50 for every extra class. I'll come on to the classes in a minute. Interestingly enough, if you claim registration of a trademark wrongly, that's unlawful. You can't actually perpetrate a fraud on the Patent Office. You can do all sorts of things with the Patent Office and claim all sorts of things, and all they're interested in doing is getting your money. They won't actually take you to task in a legal way, I suppose, unless you start doing it every 5 minutes. But trademarks is something different. If you claim a trademark as a registration, that is unlawful, and the trading standards will be down on you like a ton of bricks. So we've all heard of the fake Gucci handbags and the Rolex watches. Those are the sorts of things that trading standards take pretty seriously and say that's not, you're claiming that registration wrongly, that's unlawful, and we will take you to task. In the EU, you can apply for a community trademark, a CTM, through the Office of Harmonisation. It's more expensive, but it's €900 or 1,000 or so if you don't do it online. That covers 3 classes. And €150 for each extra class, and again it's renewed every 10 years. There are 45 classes of trademark, 34 for products and 11 for services, and generally speaking you will want to cover more than one class with your trademark, just to make sure that people aren't using it in an area which is pretty similar to yours where it could be confusing. So you want to cover a number of classes. Here's an example. Class 8 covers hand-operated implements, including razors and all sorts of things, and sidearms. But firearms is covered specifically in Class 13. So if you've got a wonderful trademark you think of, whiz-bang, spiff-spiff, pea-shooter type thing for a revolver, you'd probably want to cover it in Class 8 and Class 13. And if you want the case in which to cover your machine gun, a la Al Capone, you might put it in Class 15 to cover cases adapted for musical instruments, as well as firearms themselves, just to avoid confusion. Trademark shouldn't describe what the product does. Just an example of that, in going back to the products in the sewers and the toilets and the flood things. Flood kit and flood foam I happen to know a lot about because I applied for those trademarks myself. They weren't allowed in the UK because the Patent Office thought they were too descriptive. They described what the product did. How they thought a flood would be kitted, or I wasn't quite sure. But the young girl who was quite a new trademark attorney decided she wouldn't allow them. So we went to Europe, and the European Patent Office allowed them because they disagreed with her. So the UK is covered now on that. It's like that in this particular field. You will get examiners who have different opinions, and let's hope you find a good one. Classic case is in nappies. I think it was baby dry which was allowed because it didn't describe what you were doing to the baby, but dry baby was not, because it did describe what you were doing to the baby. So that was decided it was too descriptive. It was baby dry was not. You can have an unregistered trademark. If you use a trademark, you can just keep using it and keep using it, and you may be able to build up a reputation in that. You have to prove that the mark is yours, that you have built up that reputation, and that you've been harmed by an infringer. So you can't take someone to task if you've actually suffered no loss. And if you do manage to convince people that you have suffered some loss under the common law for passing off, there's no monetary compensation anyway. You can just get them to stop doing it. Right, I think that's covered most of those four. The other ones, the other protection, which are pretty important, confidentiality agreements. Really important to make sure that your certain types of employee are going to be covered if they're in development. You need to have them under very strict rules as to what they know they can do, what they can't do, and who owns the intellectual property, which is going to be you. That's important. Build those into the contracts of employment. Get them covered as many ways as possible. It will serve you well if you do that. And it's important to protect trade secrets. So if you have a manufacturing process, for instance, and again, something like the recipe for Coca-Cola or for Brew in Scotland, which is known by Robin Barr from AG Barr and Company and his daughter and one director only. They've kept that secret for 100 years. Not the same people, obviously, but you know, that's a trade secret, and they value it, and it's worth a lot of money. I think Brew sells as much as Coca-Cola and Pepsi, certainly in this country. So those trade secrets, manufacturing processes which mean that you can manufacture goods more efficiently, those sorts of things, you have to keep them secret. You know, you have to make sure you've taken precautions to make sure they're kept secret, and they have to have a commercial value because they're a secret. And that's the definition of a trade secret, and that trade secret lasts forever, for as long as you can protect it. Non-disclosure agreements, NDAs, very, very important if you're thinking of patents, design right, anything at all. If you're discussing anything with external people, unless they're professionals employed by you, like lawyers or consultants like myself, something like that, NDAs are crucial. I always get people to sign an NDA, to get me to sign an NDA before they discuss their ideas with me. It's for their own protection. Ideally, they should be mutual, not one way, because they're easier to enforce. So it just means that all the confidential information going between the two parties is confidential and shouldn't be disclosed by the other. Be very, very careful with government departments. Government departments are a law unto themselves, and under the Freedom of Information Act, they probably have to disclose things to other people. So if you have something which is very, very sensitive and you've got an NDA from a government department, it's worth nothing. Okay, I think that's just about it, and look forward to some questions from people. What have we got there, Caroline?
Okay, thank you so much. You've got a question here from Lee, and he asks, I work for a company, I've developed a product in my own spare time. Do I own the IP?
Okay, hopefully not. If your company has got the right agreements in place, you probably don't own it. But again, it does depend on the contract of employment between the employee and the company. It should be specific. It is very important that if that product that you've developed is in the field that your company is in, it is most important for that company to own that IP, and that should be covered in your contract of employment. If it's something totally different, then that's different. And if you're an employee and you want to write the company agreement, then you should make sure that if you're intending to do that in a totally different field, that you have their permission to do so before you do it.
Okay, thank you. Right, we've got another question here from Lucy, and she asks, how can I stop my employees copying my products and setting up in competition?
Very difficult one there. It depends again on the contract of employment and what agreement you have between the company and the employee. It is important, I cannot stress this enough, for employers to make sure that they and their employees know exactly what it is that they are entitled to do and what they're not entitled to do. And a simple confidentiality agreement probably will stop them being able to copy the products and set up in competition for a reasonable period of time after they leave you. You can't make it 10 years or something ridiculous if they're a lowly employee, because that's called a restraint of trade. But it's generally speaking, directors and people like that should be tied in for a couple of years to make sure they can't do that sort of thing, and that should be sufficient deterrent.
Okay, thank you. And another question here. Can I get a trademark for a clever name I have come up with for my product and stop people copying it?
Yes and no. We've talked about a couple of examples. I can't really answer that, and that's the same with a couple of things in intellectual property, particularly in trademarks. It does depend on the examiner, but there are a few things where you know if it's too descriptive that you won't get it allowed. But if it's something like, I don't know, let me think, anything to do with if you've got a logo on something which is a funny made-up word, like a razzle or something for a cricket bat, just off the top of my head, you want to call a cricket bat a razzle. I mean, I can't think that would not be, it couldn't be associated with what the object does, and therefore it would not be immediately thrown out. On the other hand, somebody else might have already used it as a trademark for a cricket bat. I'm not well up on cricket. So.
Okay, thank you. You've got a question here from Paul. I have designed a new process for a marketplace. How can I protect my idea under an NDA from being stolen or used later by those I have shown it to?
So you've already shown it. How can I protect my idea under an NDA? Paul, if you've already shown it to people, depending on how long ago you did that, you may be able to get them to sign an NDA and get some protection. Individual cases like that do depend on time frames, who they are, where they are in the process with you, in terms of under what conditions you have disclosed it to them. As I said before, if you've disclosed it to one of your professional advisors, then they're very likely covered anyway under their own form of working. If you'd like to give me a bit more detail on that, I could probably get you a better view. As I said before, I'm not a patent attorney. Those sort of things I would ring up my colleague, who's one of my associates in the management consultancy, ask him that, and he'd give me chapter and verse in 30 seconds, and it wouldn't cost you anything.
Okay, thank you. Right, we've got a few questions here from Philip. Is it enough to have a licensing agreement on copyrighted artwork on your website, or do you need someone to actually sign the agreement?
Again, I'm going to just say this off the top of my head because I'm not an attorney, but agreements on property, and we are talking about property here, need to be executed generally as a deed, which means that you need a signature. You can have, under ordinary contract law, an agreement can be verbal, it can be quite loose, it can even be terms of that agreement can be implied terms as opposed even to written down. This is not, that's a different field. There are agreements and agreements, and generally agreements to do with property, and that's to do with land and anything like intellectual property is also covered, needs to be covered by a signature. So, okay. Does designrunner?
Another part of the question: does the publishing of a design online form a type of registered design protection as the upload is dated?
No. This is the difference between design right and a registered design. A registered design, to get a protection of a registered design, you have to apply to the relevant office. That's the difference between that and actually having a design right. So you'd have unregistered design right in that, but you would not have a registered design. An unregistered design you have as soon as you create that, if I can make that distinction.
Okay, and then another part, Philip asks, design right applies to 3D objects. Does design right apply to the three-dimensional computer models?
CAD, isn't it? Yeah. Do you know, I'm not sure. I think that CAD, although it shows things in 3 dimensions, is actually covered by copyright and not design right. But it's one of the two, and it's always better anyway to make the model and register the design and get it covered in a more proper fashion. I have to confess, I was just asking myself that one before I came on air, and I thought, I bet someone's going to ask that, because I would have asked it myself.
Being tested. Okay, you have another question. Is it possible to protect a new process, way of doing things in a service industry where copyright may not be sufficient?
It's a bit too general, that. I'm sorry. Dear. I'd have to know more about that. You can protect things in a service industry, but I don't know why you think copyright may not be sufficient. I'm doing a lot of work with people at the moment on software, very, very complex software, and that it's an interesting one. That I'll give you an example. There are other ways of protecting things other than by copyright. So in this particular case, I'm up against some people who are saying, well, you know, it's a very grey area, copyright this and copyright that, and you know, I don't think it's going to be expensive to prosecute it. And then my answer to them was, yeah, sadly for you, we have a contract between the two parties, ourselves and yourselves as the infringing party, which says you won't do anything like this. The contract between us, between the two organizations, says you won't re-engineer, you won't back engineer, you won't tamper with it, you won't use any of it to engineer anything of your own from anything we have given you. And that is a simple contract, and that's contract law, which is much easier to prosecute, but it has the same pain, as I explained to them. And that is so it's interesting. You don't have to rely just on intellectual property. If you have an association with another organization, get another contract as well, just to keep them tied up in knots in other ways, which may be more interesting and cheaper to prosecute.
Okay, thank you very much. Lots of questions come through there. Thank you again, Hugh, for hosting today's webinar. I will be sending out a copy of the presentation and also Hugh's full contact details out to you all shortly. Thank you for joining us tonight, and we hope you can make our webinars a regular slot in your calendar. They're every Monday at 5 p.m. Hugh and I hope you enjoy the rest of your evening. Thank you for joining us.